You're welcome back to your most authoritative news analysis platform. I'm your host, Samson Ladi Anyenini. So I decide once again to shelve my take, give the 5 minutes to my guest so we can make good use of it. But on this occasion, I want to proudly associate myself with one of our regular guests. He hasn't been on the show for a long while. I'm talking about Yao Opong. Yao Opong has written and authored this very fat book, Contemporary Trends in the Law of Immovable Property in Ghana. And I'm referring to it on the occasion of the Habitat Fair, Joynews Habitat Fair, which is going on presently. So I will recommend, like Justice Jones Doche has recommended this book to everybody, not only lawyers, but everybody, particularly if you want to purchase properties and you have, because property purchase is a very big deal. You must do it and do it right. So this is Yao D. Opong on Contemporary Trends in the Law of Immovable Property in Ghana. I recommend it to you. Thank you, Yao. All right, so let me introduce my guest and we get to deal with the issues tabled for discussion this morning. And my guests are Abu Jinapor. He's a lawyer. He's Deputy Chief of Staff. Thanks for joining us, sir. Also here in the studio is Professor Ransford Jampo, Associate Professor of Political Science and Director of the Center for European Studies at the University of Ghana. Good morning and welcome, Doc.
Good morning.
Right. And when Newsfile did the flyers out and put a picture of you out, it was a picture with you with the Ghana flag, you know, around your neck. And it has generated some conversation, and some say...
I'll tell them I care about Ghana.
Some say it doesn't really look like just caring about Ghana, but it looks like a rebel. Okay. Now, Dr. Eric Odro Osai is a governance expert and a lawyer. Thanks for joining us, Doc.
My pleasure.
James Agalga is MP and ranking member, Defense and Interior Committee of Parliament. He's also a lawyer. Thank you for coming. We haven't had you here for a while.
Yes.
Yeah, thank you. All right. So once again, you may say law file, except Prof. He will deal with his own law. He started discussing with me. You will get to hear that it doesn't take reading the law to do some of the things of the law. Right. So our first issue, we're looking at the Emile Short Commission's report and the white paper that has been issued, raising a lot of issues. So I want to hope and believe that everyone here has read that report so that we can stay within the report and dissect it as much as we can. Right, so listen to this brief.
Multiple gunshots heard at the scene of an otherwise peaceful election. An MP was assaulted in the process. Masked gun-wielding men, believed to be part of the National Security Secretariat's SWAT team, were accused of brutalizing innocent civilians. Government set up a commission to probe the matter, but contradictions and varied accounts would emerge.
Later, they also said they heard gunshots coming from within the compound of the house. Our boys then gave some 6 warning shots.
There were many, my lord.
Many?
If I'm not mistaken, they were holding them. If I'm not mistaken, it will be over 20 per what I saw.
Okay. And were you able to find out the source of these empty shells, who had, you know, fired these gunshots? The empty shells that you saw, were you able to detect?
I inquired, but the information they gave me was that they were fired by the task force team that came there.
I saw them point directly into the crowd, in the direction of the crowd, and fire.
So they fired a warning shot. This made them to retreat and started to run helter-skelter.
For the angle, I don't know for warning shot, but mostly once it's targeted at this one, for warning shot I think mostly it should be up. So once it's targeted at an object below the height of maybe a normal human being, then I don't see it as a warning shot.
And therefore you conclude that they were potentially aimed?
They were
not aimed at a tree, but aimed.
I may say so.
The commission concluded its work and submitted its report to the president on March 14. Article 283 of Ghana's constitution requires the president to cause a publication of the commission's report together with a white paper within 6 months. If the president decides not to do so, he must give reasons. For now, the scars of the violence still remain.
Somebody is over there now enjoying. He just shoot me. He wanted to shoot my life. I have a family, wife and children. Now business, anything is not going on. How should I go to look my family now? Once this committee is for justice, please, I want justice must be.
The Commission recommends that the structure of reporting within the national security setup needs to be revised. In the current scheme of things, the technical person who also occupies the statutory security position, being the National Security Coordinator, is consigned to a 4th level position in the reporting strata. It is recommended that he is elevated. The Commission recommends that the police should review their recruitment procedures and install merits-based criteria to ensure that the most qualified and not the most well-connected persons are enlisted. The Commission also urged the Electoral Commission to explore the possibility of resorting to electronic voting or some other method which does not depend on physical ballot boxes. Also, the Commission recommended the criminal prosecution of Mr. Ernest Akomia, alias Double, for the unauthorized possession of firearms. The Commission also recommended the criminal prosecution for the offence of assault, to wit, the slapping of Mr. Samuel George by Mohammed Suleimana. DSP Samuel Kojo Azugu's immediate removal from command responsibility at the Ministry of National Security, given his failure to appropriately command and control the SWAT team, was also recommended. For the Minister in charge of National Security, Mr. Brian Champong, the Emile Short Commission recommended that he is reprimanded for his ultimate responsibility as Minister in authorizing an operation of that character, and on a day of an election, the Executive Secretary of the Emile Short Commission, Ernest Kofi Abuchi, is satisfied with work done. On the other hand, the MP for Ningo Prampram, Sam George, is skeptical about the full implementation of the recommendations of the Emile Short Commission.
Right. So we took you memory lane and also brought you the report. And among other things, the Commission finds that the intelligence which formed the basis for the deployment of the armed men from national security was at best of unreliable quality, and this is the crux of the matter. The Commission finds that on the said day and within the context of the events on the day, several live bullets were fired by the SWAT team, some causing injuries to members of the public. In fact, the Commission contradicts or finds as unreliable the claims of just how many shots that were made, as you heard the minister in that clip played to you a while ago. Further to this, the Commission finds that the warning shots fired were so done in reckless disregard for the safety of persons in the vicinity of this highly built-up area. The Commission further finds that the ammunition used were live bullets, and this further heightens the belief of the Commission that the shots were calculated to cause death and not to control the crowd. However, the Commission finds that there was no firing of guns at the polling station itself. The Commission finds that the use of masked men in electoral security policing represents a deviation from standard practice in Ghana. I read just one last one. The Commission also finds there was a lack of protocols surrounding the giving out of and accountability for weapons and ammunition, as well as general asset inventory taking upon the completion of mission within the establishment of the national security. All right. So the government, in compliance with the Constitution, was to either issue a white paper and publishing the report, or if it was not interested in publishing the report, to issue a statement in the national media and to explain why it was not going to publish the report. This white paper is what is now bringing all the controversy. So let's start with you. As the Commission says, it is the Chief of Staff that gave them all the facilities, the support, everything it needed to do its work and execute in an excellent manner. So they had commendations for the Chief of Staff. That's where you are coming from. Why is government accepting and rejecting portions of the report?
Well, thank you very much, Samson. Let me say good morning to your cherished listeners and viewers. And to begin very quickly by reiterating government's commendation of the Commission and its members for the work they did. The members of the Commission chaired by Mr. Emile Short, the Commission chaired by Mr. Emile Short, Professor Richard Mensah Bonsu, who was my criminal law lecturer, Mr. P.K. Achampong, former Inspector General of Police. These are eminent citizens of our country, well respected, astute in their own right, and government continues to thank them for their work. Secondly, Samson, it's also important to place it in context that reports of commissions of inquiry, findings and recommendations of commissions of inquiries are subject to scrutiny by the government. I think in the wisdom of the framers of our Constitution, when a commission of inquiry is set up, which is essentially a fact-finding inquiry, when their findings and recommendations are made, the government is vested with the authority or mandate to review the report, particularly the findings and recommendations, accept those it finds appropriate, and reject those it finds inappropriate or unable to accept for stated reasons. And Samson,
and I want you guys to take note. He says the government is mandated to review. So take note of that when we shall ask that question. Sure. Please proceed.
The government has the mandate, the constitutional mandate, to review the findings and recommendations of the report. And I will add very quickly that in doing so, you have had the benefit of the report. We have had the government has had the benefit of the report, the entire evidence adduced before the commission, the exhibits which were tendered before the commission, and the totality of the materials which the commission had. The government has had the benefit of that. And so the government, if you want, sits in a chair of having all the materials which the commission relied upon to come to its conclusions, to review the findings of the commission and make its mind as to accepting or rejecting the findings and recommendations of the commission.
So help us to understand. The government's, and I quote, the fundamental response of government to the findings of the report is that the report failed to address the first and most critical of the terms of reference of the commission, which was, quote, to make a full, faithful, and impartial inquiry into the circumstances of and establish the facts leading to the events and associated violence that occurred during the Ayawaso West Wuogon by-elections on the 31st day of January 2019, unquote. The failure to do so disables government from accepting in whole the findings of the commission. Some of the findings are accepted by government, whereas others are rejected. reasons for government's position have been assigned in the white paper. So this is damning, that government's response fundamentally, very damning, fundamentally is that they did no job, because the most important and critical term, this government's words, most important and critical term is to make a full, faithful, and impartial inquiry. They say the report failed to address that.
Well,
justify that.
Those are your words, but even
they are not my words. They are the government's words.
But those are your inference and deductions from that position of government, that government has damned the work of the commission, or that they did no work. No. Government has accepted some of the recommendations and findings. Government has rejected some. The first and most important term of reference of the commission, which was to establish the facts leading to the events of 31st January 2019, in the view of government, that has not been dealt with.
If they failed, then they failed.
They failed to deal with that term.
If they could not deal with that term,
but that is
then they did no job.
Those are your words. Now, I will be coming to the reason why government took that position. But very quickly, I was just establishing the point that reports of Commission of Inquiries, findings and recommendations have been rejected in the past. And I give you an example of the Justice Jamafi Commission of Inquiries report, where very far-reaching fundamental recommendations were made, such as, for instance, that the minister should refund some amount of money, and white paper which was issued by the then government categorically. I'll be very happy. I see that Joy FM is done. If we're a listing of those recommendations which were accepted and rejected and given a percentage, you probably should go and take the Jamafi report, check how many recommendations were rejected, how many were accepted, take the Wako Commission report, check how many recommendations were accepted, how many were rejected, and you'll be surprised. I mean, colossal sums of money were asked to be refunded to the state. The government categorically, I'll give you an example, government does not accept, at page 15 of the white paper on the Jamafi report, government does not accept the
report, as you may know, was about that embarrassing outing we did for the Brazil. Yes.
Where there was a categorical recommendation, in that case also by eminent citizens, in my view, Justice Jamafi himself and as chief judge, Mr. Fuamani, a lawyer of good standing and all of that. And government said, government does not accept the recommendation that the former Minister for Youth and Sports, Honorable Evese Free Ankara, refund the amount of 15,000 Ghana cedis reported as spent, goes on and on, an amount of 577,500 United States dollars was asked to be refunded to the public exchequer by the then president of the GFA. Government rejected. And I have done the work you did. If you go through, you will see that a substantial portion of it.
At the time, we went through this same sort of arguments. And I'm sure if we did a playback, we'll hear what you had to say about what government did on its own commission. Now, we have to deal with your commission.
Let's deal with that.
Tell us why.
Let's deal with
you have
that.
done what you have done.
Now, Samson, let me also make the point. And you know better. Commissions of inquiries, their historical and conceptual underpinnings are fact-finding. I mean, the government or the state, an event occurs, and the government wants to unravel the facts behind it and says, go into it for us. And the Commission of Inquiry goes into it. Ghana 50 Commission of Inquiry is another example when PNN and Rekubebe and Co. were arraigned before court, and the court said, you cannot use the report of a Commission of Inquiry as a basis for prosecution because essentially it's a fact-finding mission and so on and so forth. But it's also important for us to recognize that in the wisdom of the framers of our Constitution, the framers of the Constitution itself had also said, one, that when the recommendations are made, and it is stated clearly, I think in Article 281C, that the Commission has to furnish reasons leading to the conclusion stated in the report. That's one. Two, that the government may choose to publish the report with the associated white paper. Three, that the government may choose not to, and if it doesn't, it has to give reasons for. And the white paper clothes the government with authority, and indeed the legal authority supporting that proposition are bound, that the government is clothed with authority to accept or reject the recommendations.
That's not in the Constitution.
Not in the Constitution, but it's clearly established by case law that the government has authority to accept or reject, and the legal implications thereof. Now, what we can interrogate here is the reasons given for the rejection.
Exactly, that's the question I
asked. Yeah, and I'm saying to you, for instance, on the first term of reference of the commission, which the government takes the position that it was not dealt with. Samson, when you take a look at the white paper, and I hope that all of us have taken pains to critically examine
we have it, and let's be referencing it as much as we can.
Examine the reports and the white paper. You will see that government took pains to examine and review the entire evidence before the commission, and went as far as lifting portions of the evidence which were on record, which had been presented to the government, to make its case on each of the recommendations rejected or accepted. Even in some cases, recommendations that had been accepted in part, government is taking pains to deal with them. Now, let me give you an example. The commission at paragraph 1.6 on page 42 of the report stated as follows, and I quote, "The commission further finds that the SWAT team, which was deployed to the electoral grounds of the Labaoleshi School polling station grounds in complete disregard of the officially laid down electoral security arrangements, were officers of the national security establishment," end quote. You go to paragraph 1.8, and the same commission finds, and I quote, "The commission further finds that these men were deployed to follow up on intelligence to the effect that certain arms and ammunition stored in the warehouse within the constituency and to intercept and retrieve same." So by the second quote that I've just read out, which is paragraph 1.8, you will agree with me that the commission finds that the deployment was to follow up, or to follow up in their own ways, on intelligence to the effect that certain arms and ammunition stored in the warehouse within the constituency and to intercept and retrieve same. Now, when you go further, you will see also in the evidence adduced before the commission, that the commission came to the conclusion that a vigilante group associated with the National Democratic Congress, the Hawks, had been bussed to the vicinity. It is clear, I'm not making it up. It's right here.
I don't remember reading bussed, but because of the presence of one gentleman who
I'm not quoting.
Who they say his presence clearly showed that the Hawks would have been present.
I'm not quoting. Yeah. I'm not quoting. That's why I use the word bars.
Okay.
But I'm saying that the commission, the evidence adduced before the commission, thoroughly analyzed by the commission and accepted by the commission, was to the conclusion that, and in their words, let me just stay off paraphrasing. In their own words, I quote, "The commission finds that by his presence at that location, at the time when elections were taking place, a strong suspicion of the presence of the Hawks was raised."
Great.
There you go. In fact, the commission itself poses a question. Were the Hawks present that day? And it goes on to answer that question.
Yes, they do. Answer it.
Every one of the injured persons admitted having heard of the group, the Hawks. Though one claimed not to know, I think they wanted to, one claimed not to know anything more than that. In this regard, the presence of Theophilus Sedodi, a man of unusually great physique and impossible to miss, even in a crowd, was of some significance. This person, who is described on the internet as the leader of the Hawks, a militia group associated with the National Democratic Congress, was formally inaugurated at the Unity Walk of the National Democratic Congress in Kumasi. And interestingly, President Mahama led that Unity Walk. Continue. Sedodi denied before the commission that he was a member of the militia group, the Hawks. He admitted being the person photographed on the day the Hawks group was reported to have been inaugurated in Kumasi, wearing a black T-shirt embossed with the head of a hawk on the top left-hand side. His explanation of how he came to be wearing that T-shirt that day was unconvincing. And he goes on and on. On 31st January, his presence at the frontage of the parliamentary candidate's residence, and don't forget, I've just referred you to a finding of fact by the commission who says that the SWAT team had been deployed to follow up on intelligence that ammunition had been stockpiled in a location in that constituency.
Right.
And the commission proceeds. The Hawks, he was positively identified by Akomia of the SWAT team.
And Akumia is double, the guy you heard a lot about.
Yes, double. So I'm establishing the nexus. I'm establishing the nexus.
The mobile phone seller term security
has been present in the restive crowd at the frontage of the parliamentary candidate's house that morning, leading to his subsequent chase and arrest by the SWAT team. And then the commission concludes. The commission finds that by his presence at the location at a time when elections were taking place, a strong suspicion of the presence of the hawks was raised.
Right.
Now, if you read the executive summary or even read just the report, you will not find this. If you read the executive summary as in the findings, you will not find this portion that I've read out. You have to go and read the analysis of the evidence to find this.
You are reading this under what heading of the report?
This must be under the analysis of the evidence. If you go to the report, the analysis of the evidence, this evidence.
No, I'm inviting you to go and pick where it is coming from, so that we all know that that's what you're saying.
No problem. No, don't worry. That's at paragraphs 1.2 to 1.22 on pages 34 and 35 of the report.
Right, and it comes under what heading?
Let me check it for you, please.
Yeah.
Where is it?
Okay, this. Okay.
This is the report.
Okay.
Page 34.
Right. Okay, so.
So if I may conclude, so essentially in answering Samson, I'm seeking.
Sorry.
No.
Yes.
Assessment of evidence.
Yeah, assessment of evidence.
No, wait.
Yes, correct.
Great.
So this was evidence adduced, accepted, and assessed by the commission.
Great.
And in the assessment of the evidence, the commission comes to some conclusions. So this is the point we have made, which is that the facts which led to the events of 31st January 2019 was, in our view, in the view of the government, one, that the national security apparatus had picked intelligence, that ammunition had been stockpiled.
Intelligence with the commission comes to a conclusion was at best of unreliable quality.
Which the government has commented on.
Okay.
Which we have commented on.
All right.
And which we have, which is, I'm answering
Proceed
the question.
With the point,
yeah, I'm answering the question you asked about why we took the view that the first and most critical term of reference of the commission was not resolved, if you want. Which is the point I'm making. And if you want, I probably should begin with what our position as to.
So your problem is that this is an assessment they made. You are happy with the assessment. However, the assessment should have found itself on some pages of the report, and it was not there.
No, more than that. That when you take the evidence before the commission, and I don't want to be boxed into a position of, if you want, something that smacks of running down the commission or attacking the work of the commission, or coming to the conclusion that government entirely is against the work of the commission in totality. Because they are very far-reaching and fundamental findings and recommendations of the commission to accept it by
Nobody
the government.
Can say government is entirely against it.
Because the report you have pinned me down on one particular issue.
Right.
And which is what I'm trying to establish. And that point is that when you take the evidence before the commission, you take the evidence accepted by the commission, some of the findings of the commission itself, and you take the totality of all of that, the conclusion is that the facts which led to the events of 31st January 2019 were that, one, there were stockpile of ammunition and arms in a location of Ayawa's West Wagon, where by-elections were being held.
That was established?
No, that was established.
No,
not established that they were, that they followed up on intelligence. Not established that they, in fact,
is the intelligence of unreliable quality.
Which is what we are quarreling with. And if you allow me to
no
finish.
arms were found or retrieved.
No problem. Nobody says so.
Okay.
No one has said so. But I'm saying that there was that intelligence.
Great.
That if you take the evidence adduced before the commission about the hawks, if you take other pieces of evidence, if you put all of that together, the facts which led to the events of 31st were that intelligence had been picked, that intelligence was actionable, and which resulted in the deployment of legitimate official national security operatives, contrary to what the national chairman of the NDC had told all of us. And I see that, you should pay attention to that too. I mean, that is also very fundamental, that the chairman of a party says that people of unknown armed vigilantes wearing national security uniform brought from invincible forces had been deployed into a constituency, that 10 of them per polling station, 100 polling stations means 1,000 of them, the commission finds that indeed there were no disturbances in any of the polling stations. Right. They said it was close to the polling, but not in the polling. So essentially, the national chairman was not accurate. Sam George, member of parliament for Ningo Pram Pram, had said categorically that someone had been shot and killed in his own house. The commission is turned out not to be accurate. And that deployment that deployment, to follow up on that actionable intelligence, is what led to the events of 31st January 2019. Actionable intelligence, intelligence which required action by national security operatives. So that is the
If you can get to the bottom of this for me, because as I read, my question to you is it your case that this assessment is not part of the Commission's report, or that even though it is part of the Commission's report, it ought to have been given a certain significance that it was not giving? That's why you are fighting the Commission on this.
The latter. The latter is correct. The weight placed on this evidence, little weight was placed on this evidence.
Okay.
And that if the proper, appropriate weight was placed on this evidence, the Commission would have found clearly that the intelligence which the national security outfit acted upon was credible intelligence, was intelligence of quality, was actionable intelligence, which indeed is the bedrock or the foundation precipitating the events of 31st January 2019.
All right. Now that's clearly understood. Please proceed to your next other ground of disagreements.
Well, not necessarily disagreements. I mean, so that is one of the areas
disagreements
that
are fair.
No, I hear you.
And disagreement is used rather, what you use here is reject, not disagreement. You reject.
Yeah, exactly. Which is actually the language that white papers normally adopt. Now, and I've been making the point, Samson, that we have to look at the Commission's report in its totality, situate it in the context of the events of 31st January 2019. And I've been making the point about some of the statements which were categorically made, or allegations or claims which were made by leading members of the opposition. I see that my friend, Honorable Sam George, is so livid and has been writing all sort of statements and quoting the Bible to the president and the rest. But again, something, he should be consulting you, because you will find also in the report that very damning adverse findings have been made against him. Member of Parliament, an honorable member of Parliament, whom the Commission found very clearly that he had asserted.
And let's not use that adverse finding has been made against somebody lightly. Let's point to where exactly it is, because this is the consequence of adverse findings by a report. When there is an adverse finding made against you by a commission of inquiry, upon the expiration of 6 months, preceding after the white paper or publication has been done, that report becomes a judgment of the High Court, and you can only appeal to the Court of Appeal. If you don't take steps to reverse it, or you are unable to reverse it, you cannot be an MP, you cannot contest to become a president. It is very damning. So when you point to, you say adverse finding, please take us there. Don't say it.
That's why I say you should consult you. Because
the appeal is as of right.
Yes, as of right.
Within 3 months.
Within 3 months.
But that's why I say you should consult you, because I'm not too sure.
Okay. All right. So you know what? Do this for me. Do this for me. Just hold on.
Yeah.
Go over what you're about to present. Hold on. Wait.
Okay.
Go over what you're about to present, and when I return, we'll hear you. I want to go to the phone lines and speak to John in Debugre. He's a lawyer and former MP. He's played many roles as a citizen, and now obviously a senior citizen. Thank you very much for joining us, John in Debugre. Okay, we lost him. Okay, so he's been making some very, very interesting comments. You know, there was a recommendation for the reprimand of the minister, Brian Echampong, on the basis that that's a minister of state who is at the national security, that because he had ultimate responsibility, he should get a reprimand. The government rejects that completely. Thank you very much for joining us, John in Debugre. Oh, we lost him again. We will get him. When we do, we'll let him justify why he says he should be prosecuted instead of just being reprimanded. Yes, go to your next point.
So something I've just been saying that perhaps Honorable Sam George should be consulting because
should be consulting a lawyer.
Yeah, a lawyer. I have no position as to whether or not this is adverse. I mean, but it's a serious matter that he needs to interrogate because if you look at paragraph 2.15 on page 40 of the report, the commission makes this finding, and this was a finding in response to an assertion he made.
And he made
passionately in the words of the commission, which the commission makes a definite finding of fact on it. And I quote, he said, "We find as a fact that this unit was set up between 2010 and 2012. It is thus and true that this unit was set up under the current MPP administration that took office in January 2017. Although Honorable Sam George asserted with conviction, if I even use words than passion actually, conviction, that the unit did not exist at the time he served in government at the office of the president, he was clearly mistaken because it did. Perhaps it may be their special uniforms that are new, but certainly not their existence code." Now, I take note of the usage of the word mistaken. That is where the issue is. I mean, if the commission had, for instance, said he told a lie or that it's, or even if it's untrue, it still becomes contentious. But the point I'm making is that he testified on oath, number one. Number two, he made that categorical assertion on conviction that this SWAT team never existed under the previous administration. It was set up suddenly to unleash violence on the Ghanaian people. And never forget something. You have to situate it in the context of the claims and the allegations, which is indeed, amongst others, what caused public and national outrage in our country. What is happening? That we are told that a certain unknown armed men, vigilante groups from the Invincible Forces have been unleashed onto Ghanaians. Akufo-Addo and his government is set up a certain militia group and so on.
In the light of this statement and the conclusions, the finding as made by the commission, that this assertion he made with conviction is untrue, and that at best he was mistaken, you want to say that they ought to have elevated this because they have come to the point that he spoke on truth, and speaking on truth on oath means you are committing the crime of perjury.
That's right. That's right.
And so they should have elevated that. They didn't do that. For saying mistaken, you disagree. That's the point.
Well, no, not necessarily. I mean, I'm not even, I'm not disagreeing, or I don't have much difficulty. I'm just raising the legal implications as you
are raising because you have an issue. What is your issue?
My issue is that this finding of fact against Sam George potentially constitutes an adverse finding by a commission of inquiry.
And the commission should have stated so.
It would have been, it would have been more welcoming if the commission had expressly stated so in their, but it still doesn't take away the fact that they found so.
All right. Okay, so let's go to Mr. John Ndebugri. Thank you. Let's speak to John Ndebugri and come back. And when we do, I'll let you also share with us what you think that if it had been a minister in charge of security who was in charge of security during Mohammed's period, who had been questioned, then they could be saying he's lying. But for someone who was not a minister or was not in the security arrangement, is it okay to say he was mistaken, even though he stated with conviction? Okay. All right. Thank you for joining us, Mr. John Ndebugri.
Good morning, Samson.
Thank you very much for making time for us, sir. Now, first, let's go to what one of the points that you raised, and then you can share with us also your general view of what should be done in the implementation of the report. You say the recommendation for a reprimand for Brian Echampong for ultimate responsibility is not good enough. There should rather be a consideration for prosecution. How is that possible?
Well, yeah, I'm happy that, good morning to you and then your panelists there, particularly Honorable James Agalga, my junior in the past. You see, you put it right when you said that I should possibly comment on what I have said already and from other things. I want to suggest to you that we should structure the discussion in this manner, taking note of the following. You see, the commission, I'll come and answer the question about Mr. Bright Achampo. The commission deliberately structured its report in 5 areas, thematic areas: structural, operational,
right,
individual liabilities,
right,
compensations, and general.
That's right.
As far as I'm concerned, what really captures my concern, because your program is limited, what really captures my concern is the structural. The recommendations contained in the structural recommendations and the white paper's response there.
Okay.
And maybe to some extent, the individual liabilities. We can discuss the operational aspects at another time.
Okay.
Yes. So it is unfortunate that the government of the Republic treated the structural recommendations in your terms, pick something. But
cherry picking.
With some swift dismissal. And I don't want to incite my learned members of the commission against the government. But the beginning of the preamble to the white paper condemns the members of the commission that they were not fair, they were not impartial, they were not truthful. And I am amazed as to how these eminent gentlemen and ladies could be so untruthful, so unfair, so impartial. Because I know all of them.
So sorry, did they say they were untruthful, unfaithful, or they said they did not? That they did not. No, if I may be heard, he said they failed to do a faithful and impartial. Is it the same as you are unfaithful, you are untruthful?
You are a lawyer. They fail to do. We normally address our letters with you fail or neglect or refuse. And if you are, as a lawyer, if you write a letter to me that I have failed to do A, B, C, it means that I have not done A, B, C. So they were to do on fair, truthful, the other
impartial.
Impartial.
That doesn't mean
investigation. Then the report says you failed to do this. What is the meaning of that? That we don't need to argue on that. It's a matter of interpretation. My interpretation is that the government is telling the commission that they did not do those things. They were not impartial. They were not truthful, or they did not do the investigation truthfully, impartially, and the other one
faithfully.
Yes, and I am saying that that is already a problem, because what is the reason for these eminent persons to do things impartially, or partially, untruthfully, and unfairly? That is a matter beside the point.
Okay.
But let me come back to the report. I'm saying that let us emphasize on the structure. The report on the structure.
Yeah, recommendation on structural problems.
You see, the people keep on saying national security. I've said it many times, but well, they don't pay attention. There's nothing like national security. The Constitution mandates the establishment of a National Security Council, and its functions are clearly, set out in Article 83 or so of the Constitution. The functions are clear. Yeah. So when people say national security, I don't get it. There's a National Security Council, and Article 85 of the Constitution forbids the establishment of any security organization outside the organizations established by the Constitution. So when you go and establish when you go and establish a national security minister, what is the meaning of that? It is in direct contravention of Article 85.
Interesting.
And you go and establish a national security minister of state or a minister of state at the presidency in charge of national security. It is still worse. And you go and establish a police station with an armory in the National Security Secretariat. The Constitution only recognizes a National Security Council Secretariat. It doesn't recognize a National Security Police Station. And you go and establish a National Security Police Station, and you call yourself National Security, and you go and recruit hoodlums, and you train them and build them into muscles.
But the commission didn't find that.
Lead them on people. That is in direct contravention of Article 285 of the Constitution. So structurally, what the commission, in my view, my humble view,
be allowed to comment?
in my very humble view, what the commission members were trying to do was to draw the attention of His Excellency the President to the fact that they've departed from Article 85. So go back and restructure. And they said somewhere about the National Security Coordinator. He's the only one recognized in the Constitution.
Yes, they say he should be the one in charge and be reported to by all subordinate national security operatives.
He is the only person to be there. The question of National Security Minister, Minister of State and National Security is job for the boys. They are redundant. They are a pestilence. They must be removed. They are a pestilence.
The creation of ministries, is at the discretion of the president.
Yes. But
so what's illegal about it?
You cannot exercise your discretion against provisions of the Constitution. The Constitution says don't establish a national security organization not recognized by the Constitution. Where is it in the Constitution that you should appoint a national security minister? So, Samson, let me just finish with you quickly so that...
A national security minister is not an illegal armed force, which the Constitution is against.
Pardon me, sir?
A national security minister or ministry is not what the Constitution contemplates and prohibits. It prohibits forming or establishing an armed force which is which is not mandated by Parliament.
Have you read Article 85?
Let me read it.
Yes, please. Please, Dr. Drosa wants to read it for your hearing again.
Yes,
I will listen.
Yes,
okay.
in Democracy, Article 85 of the Constitution, which is under the heading Establishment of Security Services. Yes. No agency, establishment, or other organization concerned with national security shall be established except as provided for under this Constitution.
So a ministry is not an organization or an agency or whatever. What are you talking about? This is a question of interpretation. Okay. I am saying that I interpret that thing to mean that the only person who is qualified to be there is the National Security Coordinator.
Okay. But you're not mentioning the Constitution. The National Security Coordinator is
an organization. Is it established in the Constitution?
It's not mentioned.
Okay. So to the issue you mentioned earlier.
So what's he talking about?
Am I allowed to continue?
To the issue you mentioned earlier. Sorry, don't be interjecting. Wait. The issue you mentioned earlier, the recommendation was that the commission recommends that Mr. Brian Champong be reprimanded for his ultimate responsibility as minister in authorizing an operation of that character on a day of an election in a built-up area. You say that they are treating him with kid gloves.
No, that came under. I am now discussing the white paper.
That's right.
The report and the white paper.
The white paper rejects this.
About what I had said earlier when I had not seen the report and the white paper.
Okay.
And I'm saying that in my humble view, we should look at the recommendations in 5 areas,
right.
structural, operational, individual liability.
Right.
You have jumped to individual liability. I'm talking about structural, which is the most important thing for us. I am saying that the recommendation that the SWAT team, whatever operational group is in that so-called national security, whatever, should be disbanded, must be enforced.
Okay.
Otherwise, my brother, and NDC people sitting there, you've lost the elections already.
Oh.
Because these goons have been trained to go there and disrupt the election so that somebody will win. And the commission says, disband. And you say, no, you won't. I have heard this, your panelists talking plenty there. I think that he wasn't making a point. We're talking about a commission of inquiry established in 2019, not a commission of inquiry established about football, flying of money across the sea to some place in some 2007 or so. So it shouldn't waste our time.
Okay.
Now, let me finish. Finally, you see, I have a problem also with the commission in the sense that Article 280, Clause 2, states as follows. With your permission, I'll read. Where a commission of inquiry makes an adverse finding against any person, the report of the commission of inquiry shall, for the purposes of this Constitution, be deemed to be a judgment of the High Court. And accordingly, an appeal shall lie as of right from the finding of the Commission of Inquiry to the Court of Appeal. So, I mean, these eminent commission members were aware of this provision, and they are aware of Brobe and
Republic and Brobe and MPNE
case. And so to recommend that people should be prosecuted, I am amiss about that. And I had said at the beginning of the commission, if you go back and Google, you will see that I said that the establishment of the commission was either pointless or it was calculated to prevent the prosecution of criminal elements.
Okay.
And that is what has happened. The commission says that they should recommend that they should be prosecuted. You cannot. All they can do is that they should refer them to the High Court for sentencing.
Okay.
Because the commission cannot sentence. The commission will find you culpable and pronounce, and then you have to go to the High Court to be sentenced. So
how is that done? How is that done? How is that possible when there's already, if an adverse finding is made, an appeal is available? How do they go to the High Court for sentencing?
If you don't appeal within the stipulated time, or even before you appeal before the state, you should refer to the High Court for sentencing.
We'll explore that. Thank you very much for your interesting views. We'll explore that too. Thank you very much. John Indebugri is a lawyer, former MP, and he's been many other things, right? Yes. Okay. So, so I'm checking, and we are on the top of the hour now, right?
If I can make a quick comment.
Yes, quickly.
Well, Samson, first of all, the matters he spoke to about the members of the commission and the position of the government as to the first term of reference, I think that one is just mischievous propaganda. I think you quite rightly was trying to put him right, but he will not listen to you.
You mean a former member of parliament on the ticket of the NPP is doing propaganda against you?
Clearly, that's the submission he made. That was clear propaganda. He was just politicking. He's just trying to incite people and so on and so forth. When Prime Minister Gordon Brown appointed Sir John Chilcot to inquire into the Iraqi war and the circumstances of the Iraqi war, and he presented his report, the parts of the reports which were rejected or jettisoned by the government of the time did not by any means reduce the standing of the members of the commission.
Okay.
So the fact that the government rejects parts of a commission's report doesn't mean that the members of the commission have been damned or condemned or any of that. Now, number two, it's obvious that Mr. Ndebugri hasn't read the report in full, because if he had read the report in full, he will not be this misled into coming to the conclusion that the government of Akufo-Addo has set up hoodlums and a SWAT team and so on and so forth, and that is going to result in the defeat of the NDC. He should read paragraph 2.15 on page 40, which I've just read here, where the commission found categorically that the SWAT team was established in 2010 and not under Akufo-Addo's government. So he's clearly not read the report, because if he reads the report, he cannot but come to the conclusion that this SWAT team was established at the time when my good friend was in government. At the time when President Mills was the president of our country, the SWAT team was not established under
Maybe
Akufo-Addo.
an alternative, conclusion is also reachable by him when he reads, where they clearly suggest that unless these guys were sent there to, as it were, scare people and so on. So it's about the use at this time. So the real question is not about when they were established, because that one, we know that while Sam George was speaking there and said they were recently established, we all knew that
they were even paraded at an Independence Day celebration.
Right.
And I'm saying to you that Mr. Ndebugri has stated on your show categorically that this SWAT team, hoodlums, he uses the word hoodlums, were put together as a SWAT team by Akufo-Addo's government. And I'm pointing to him that if he goes to page 40 and he reads carefully...
He made that categorical statement?
Oh, he did. He said so. He said, and that if the SWAT team is not disbanded, then NDC will lose it. But finally, I find it also very...
If you look at page 55 of the report, what the Honorable Ndebugri said in relation to hoodlums and their integration into the security apparatus finds expression in page 55 of the report.
And
they call them hooligans.
Yes,
it's captured. Oh, that's fine. But the report clearly says that the SWAT team was established since 2010. The report also says that successive government...
So let's not belabor that. Thank you. Let's not belabor that.
The Minister for National Security, I'm very surprised. The fact that there's a police council, the fact that there's a Ghana Police Service, the president cannot appoint a Minister for Interior. What sort of logic is this? The fact that
Minister for Interior.
No, I'm saying, I'm establishing the logic of his argument that there's a Ghana Police Council established by the Constitution, there is a Ghana Police Service, just as there's a National Security Council and the National Security Secretariat. The president cannot, pursuant to the executive powers reposed in him, appoint a minister to be responsible for the functions vested in him as president for national security.
So the minister is appointed to oversee a secretariat.
Is appointed to oversee the functions of the president in relation to national security as established by the Constitution.
And what has the Constitution established?
The Constitution established...
A council with a secretariat.
Yeah, that's fine. All. But the function, the role that the president has to play in this National Security Council, National Security Secretariat, as established by the Constitution, that role, the president has the right to delegate it to a minister.
The Constitution clearly, and the Intelligence Act, says appoint a coordinator.
Yeah, but there's a coordinator. But ministers exercise delegated powers. The minister is like the minister essentially.
And for the first time in our history, you have two ministers in that regard.
We can interrogate that.
Okay.
No problem.
All right. Let's take a break. Let's take a break, and
I find nothing wrong with that.
When we return, I guess I've seen them writing and annotating the reports and the white papers. We'll hear their views. We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And here on Newsfile, we put Ghana first. Now, let's have Dr. Odo-Osain also share his perspectives with us about the report of the commission and vis-a-vis the white paper. But it has to be stated that the president is actually empowered by law to appoint a minister responsible for this sector. And in the Intelligence Act, there's a provision for that. It does appear his role is very limited to be able to report to Parliament, because a coordinator may not go to Parliament and give a report on matters of security.
Section 17.
Yes, Section 17 of the Act. Yes, so what do you say? Taking it from where Ndebugri, begins, that the opening statement of government is a personal indictment on the commissioners?
That's something I disagree with Mr. John Ndebugri. You see, apart from the commission having a very short tenure, I must say 1 month, it's very short for them to do a very thorough work. The terms of reference given to the commission is one of the unique terms of reference given to such commissions. The only one that comes to mind is the WACO Commission. Now, when you look at Article 281A, it is clear on the expected functions of a commission of such nature. And it is clear that it is saying, Article 281A is saying, a commission of inquiry set up under this article shall make a full, faithful, and impartial inquiry. This is a constitutional requirement.
Right.
The terms of reference given to the commission is also clear, and that is the #1 terms of reference, that you should make a full, faithful, and impartial inquiry. This is a committee set up by government. They've given the terms of reference. The first one lifted from the Constitution. Now, if you have submitted your report and the government says, and I'm reading from page 5 of government white paper, the fundamental response of government to the findings of the report is that the report failed to address the first and the most critical of the terms of reference. And here I'm adding the constitutional requirement of the commission to make a full, faithful, and impartial inquiry into the circumstances of and establish the fact leading to, etc., etc. I was thinking that as soon as this statement is made and it is linked to the Constitution, the report should be rejected.
Completely?
Completely, absolutely, because you have failed to meet your constitutional obligation.
The first and most critical.
The first and the most critical, not only as per your terms of reference, but as required by the Constitution. Article 281A says so. Now, has the government got the right to determine whether they have met the standard or not? Yes, in my view, because it is the government that sets you up. It is the government that gives you the terms of reference. So the government has expressed its view. Now, let me also say that the government, in my view, never reviewed the report. The legal mandate and obligation on the government is to express an opinion and a position on the report. So I heard my brother saying review, but I believe that the government expressed an opinion, and it is within the powers of government.
They did not do more than opinion, sir, because, and I agree with him, he states it quite rightly, that they did a thorough review. And when I read what they have done, they even went beyond what the commission has done to go and bring the testimonies to come and challenge some of the assertions that the commission has made. So, in my view, it will appear as if they did a job of a court of appeal, sitting over a job that has already been done, doing a rehearing of the case.
Well, Samson, you see, those are the background work they need to do to express an opinion.
Do you know in history, is there precedent where anytime there's a rejection of any point, they have gone to the evidence, the body of evidence, to use to challenge a commission's report?
No, not that I know of for now.
There's one here.
But what I can say is that definitely they cannot express an opinion without reviewing. But there is no law placing an obligation on government to review a commission's report.
Okay.
That I want to put it on record. They have to express their opinion and their views, and they have done just that. And my view is that once they fail to meet the most critical and the fundamental terms of reference, not only as per the one given to them by the government, but the one indicated in the Constitution, the report should have been rejected. That notwithstanding, the government has accepted parts of the report and rejected parts of the report, which is normal in my view. But I think that the fundamental problem we are faced with as a country now is we should be able to review and interrogate the power of the executive or the government to review Commission of Inquiry's report. That is where we need to tackle. Because it happened under the JMP Commission, it happened under the WACO Commission, it happened under Ghana at 50. Constitution Review Commission's report that they told the whole country, interrogated people, Ghanaians expressed their view, a constitution that belongs to us. The commission submitted their report and the white paper was issued. Majority of the portions of this white paper was also rejected. Then we come to the Asha report, which was a white paper, was also issued. So my thinking is that we've come to a point in our governance architecture where that bit of the Constitution, Article 280 onwards, must be reviewed. If indeed we want to make significant progress, we cannot fault government, we cannot fault anybody for accepting or rejecting the Commission's report. It is our making. We have given government the power to express its opinion. And indeed, in a country of rule of law, you hear both sides. You don't go and hear one side and leave government, because government also has a view. So I think that we should take steps towards ensuring that we review that aspect of the Constitution that gives the power to the President to review a Commission's report.
I see. In the first place, you say there's no that power to review a Commission's report. But having been conversant with judgments like that of the Republic versus Rekubrube and Impieni, do you come to the conclusion that the judge in that very seminal judgment was trying to educate all of us by going back to the history of the Constitution making and coming to the point that commissions are for the purposes of finding what we have done wrong and how we can correct them, and that they are for the purposes of policy moving forward, and that in fact they appear, the recommendations should take the nature of an Article 146 decision, which the Chief Justice will do, and when they sit and say a judge has committed some mistake or somebody has done some wrong, like removal of the Shraj boss or removal of the Electoral Commission boss, once they bring you the recommendation, you have no discretion. You must go ahead and implement it. Is that how it's supposed to be?
I want to agree with that. But you know, that judgment was given at the High Court level.
That's right.
So then we need to go to the Supreme Court, for the Supreme Court to make a pronouncement on it. Because it seems to me that if we tow along that line, it will really help us. Because I can tell you, this will not be the last commission. We may have more commissions coming in future, and government would express its opinion on the commission's report. We'll come back to this discussion again. The fundamental solution should be, let us work towards amending that part of the Constitution.
Okay. James.
We're living in interesting times. I have read the white paper of government and signed by the Attorney General with so much shock and disbelief. You see, what the white paper essentially has done is to say that the work of the Emile Short Commission in its entirety is unconstitutional. And I think Dr. Sai has addressed that issue in a manner that I would want to associate myself with. I mean, he's referred us to the constitutional provision, Article 281A, which actually says that, and it comes under the heading Functions of Commissions of Inquiry. And one says a commission of inquiry shall, it is mandatory, make a full, faithful, and impartial inquiry into any matter specified in the instrument of appointment. So this is a requirement. Anything short of this requirement will mean that the commission's work was unconstitutional. And so once government comes to the conclusion in its white paper that the commission failed to make a full, faithful, and impartial inquiry into the circumstances surrounding the Ayawaso West Uagon by-election, which was characterized by violence, it did not lie within the power of government at all to have then proceeded to accept portions of the commission's report and reject some. It didn't lie within their mandate to do so. To do that means that government then in itself has also acted unconstitutionally because it has not applied a key provision of the Constitution relative to the functions of commissions of inquiry. So they shot themselves right in the foot when they arrived at that conclusion. They themselves stated that their fundamental response and objection was that the Commission of Inquiry did not make a full, faithful, and impartial inquiry. That, for me, has far-reaching consequences. What it simply means is that the Commission of Inquiry, its chairman, Emile Short, Professor Henrietta Mensah Bonsu, Patrick Achampong, former Inspector General of Police, and Kofi Abochi, former Dean of the Law Faculty of GIMPA, all acted in a malicious manner. Oh. And that is what it means. That is what it means to say somebody has not acted in good faith.
No, but maliciousness.
Excuse me. What is the meaning of acting in good faith?
No, but if you've not acted in good, it doesn't mean you have been malicious.
It is a legal phraseology.
No.
Which even has equitable connotations to say somebody has not acted in good faith.
Did the white paper say it is the report which failed, or it said it is the individual commissioners or the executive secretary of the commission?
This distinction will not fly. The report is the handiwork of the commissioners. So if we're saying that the report fails to make an impartial, a full, and faithful inquiry, you are, in another sense, indicting the members of the commission. Wow. And I'm saying that that is most unfortunate.
I'm not qualified to untie the sandals, the lace of the sandals of Henrietta Mensah Bonsu, for example. But are you saying they are infallible?
No, nobody has said that. But the point is that if you reach that conclusion in your opening introductory remarks about why you would accept portions of the report and reject some, you have shot yourself in the foot and have established the constitutional basis for that argument. That they could have accepted portions of the report and rejected some other portions of the report without stating with emphasis that the commission failed to make a full, faithful, and impartial inquiry. Once you do that, you disable yourself from proceeding to accept portions of the same report that you have said was not made in a faithful
Let's
and
pay
impartial
attention to this portion of
manner.
the white paper. And let's ask ourselves if this portion of the white paper is something you cannot bear with. In the findings, point 5.1, electoral security. The government accepts in part the findings of the Commission on Electoral Security as captured at paragraph 1 on page 41 of the report. The government makes the following specific comments on the findings on electoral security. And I'm leading us to a point where you may make a concession that the Commission may have done something that they didn't, particularly pay attention to. They say that A, the Commission's own findings in paragraph 1.6 on page 42 of the report, which the government accepts, contradicts the Commission's findings in paragraph 1.8 on page 42 of the report. The government rejects the findings that the SWAT team was deployed to the electoral grounds for the purposes of electoral security. The said paragraph 1.6 provides, so this is the Commission saying, and this is the finding it made. Quote, the Commission further finds that the SWAT team, which was deployed to the electoral grounds of the Labawaleshi School polling station grounds, in complete disregard of the officially laid down electoral security arrangement, were officers of the National Security Establishment. Then in paragraph 1.8, they say, the Commission further finds that these men were deployed to follow up on intelligence to the effect that certain arms and ammunition stored in a warehouse within the constituency and to intercept and retrieve same. So the point they are making is that
if you read further, it establishes the contradiction clearly.
Okay, so let's read. They say from the foregoing paragraphs, the Commission finds in one paragraph that the SWAT team was deployed to the electoral grounds for electoral security. And in another paragraph, the Commission finds that the SWAT team was deployed to follow up on intelligence. The evidence of the chairperson of the Electoral Commission, Mrs. Jean Mensah, given before the Commission, which evidence was not assessed in the Commission's report confirms that there were no armed marksmen at any polling stations in the Ayawaso West constituency, and the SWAT team was not at any polling station. So,
Samson,
what do you say about
Samson,
this?
Samson, I'll get to that. You see, what they did, essentially, was to pick and choose from the report, and even in some cases, findings of fact were simply taken out of context for their purposes and interpreted. For me, that is most unfortunate. Look, the commission adopted a certain methodology, which methodology has not been impugned anywhere in the white paper.
They say this is a contradiction.
No,
is it a contradiction for you?
No, it's not.
Why is it
I'm
not?
building. I'm making a point that the commission adopted a certain methodology. For instance, and you were counsel, you represented a client who appeared before the commission. Witness credibility was tested through cross-examination. They had a way of collating their evidence and storing same. They used rigorous questioning techniques. And if you like, they actually, in some cases, okay, drew inferences in arriving at their conclusions. So if you decide for your purposes, for government's purposes, to zero in on one particular finding and treat that in isolation and not within the proper context within which that finding was made, you'd run into challenges.
So keep to this specific one. Can you keep to this specific one? James, James, please keep to this specific one.
Yes.
They say the commission ought not be heard to, in one breath, say that this was an election security operation.
Yes.
Then in another breath, to say that they were there for the purposes of intelligence that they were following up.
Samson, if you read...
They say that's a contradiction.
Yes, if you read the report in its totality and analyze the evidence in its totality, there are no contradictions in the conclusions the commission arrived at.
Okay.
First of all, why? The commission established in page 46 of its report, okay, that the deployment was actually done within the premises of the residence of the parliamentary candidate of the NDC, which was proximate to the electoral grounds. It was proximate to the electoral grounds.
That's okay.
And so, Samson, what inference can you draw from this? If you decide to take out the conclusions arrived at out of their context and state that the chairperson of the Electoral Commission testified and actually gave indication that there was no such deployment in any of the polling stations, it means that you have not adverted your minds to what is captured under page 46 of the report.
They found so.
They found that the deployment was done at the residence of the parliamentary candidate, which is proximate to the polling station grounds. So whatever happens there has ripple effects. It affects the conduct of the elections at the polling station. And there is evidence in the report.
Okay.
The happenings in the residence of the NDC candidate not bring to a halt the elections for close to an hour at the Labawaleshi polling station. So, Samson, what they have done for me is unacceptable, and I've made the point that they have not even attacked the methodology that was used. And so when you do that, it's like a court of law. Evidence is elicited from witnesses. The opportunity to cross-examine was given. Proceedings were telecast live for the consumption of all. And so they did their analysis. The commission did its analysis, you know, in taking into account the generality and the totality of evidence that they were able to elicit. And in some cases, they extrapolated. They made reasonable inferences in arriving at some of the conclusions. Let me just give you an example. For instance, on the issue of the unreliable quality of intelligence that the national security operatives claimed they had. Why? The commission did its analysis of the evidence that was before it and came to the conclusion that, look, the evidence was of unreliable quality because they claimed they went there to retrieve firearms, and that was the intelligence they had.
Right.
But no attempt whatsoever was made to retrieve any firearms. Right. Did they retrieve any firearms?
It was an aborted operation.
Why was the operation aborted?
It was aborted.
Why was it aborted? There was total lack of coordination.
That's another
matter. The evidence was not ranked, rated, and assessed properly.
That's another matter.
That is another matter, but it was part of the analysis they made in arriving at those valid conclusions that you have impugned. I've read the white paper in its totality. So, Samson, with the greatest of, but the line of questioning has even distracted my
because you have come to talk about.
So let me also inform you that the commission in its work visited the locus incu.
Yeah.
That is very instructive.
That's okay.
And so the evidence that was elicited from witnesses had to be tested with the visit to the locus incu. For instance, when DSP Azugu testified, and in a way you have stated in the white paper that there was corroboration to the fact that gunshots were fired from within the residence, okay? The commission visited the locus incu and did an assessment, the trajectory of bullets with expert assistance and advice, and came to the reasonable conclusion that gunshots could not have been fired from within the residence of the PC, the parliamentary candidate.
Or fired into the air,
absolutely, because of the trajectory of the bullets. What they observed was that the bullets were fired into the direction of the residence. There was no evidence whatsoever that bullets or ammunition were fired from within the residence. If they had fired from within the residence, the impact could easily have been assessed and conclusions arrived at. You see, in any case, the fundamental point I want to make is that most of the conclusions and findings of the Commission of Inquiry hinged on law. Unfortunately, the report missed the point. And I am surprised, with the greatest of respect, that the Attorney General is the one who appended her signature to the white paper. Let me take the case of Honorable Sam George and the conclusions arrived at in the white paper. For instance, the commission clearly made the finding of fact that Honorable Sam George was assaulted together with others who were found within the premises of the PC whilst they were in flight. Now they then proceeded to recommend for the prosecution of Sam George's assailant, Mohammed Suleimana. In the white paper, the government of Nanadu has stated emphatically
His Excellency,
that recommendation is untenable in law because Suleimana Mohammed has a defense in provocation. Shocking.
They didn't say defense, valid defense of provocation for the assault.
This is shocking.
Why is it shocking?
A first-year law student knows that the defense of provocation
on the wrong path.
Will not avail somebody charged with criminal assault. A first-year law student knows this.
Everybody knows that.
It is a basic principle.
You know that?
Of course we know
Section
that.
53.
You know that?
Yes.
Samson. Section 53 of the Criminal Offences Act of Ghana is very clear. The defense of provocation can only be invoked in cases of murder.
That's okay.
So how could the Attorney General of the Republic append her signature to a white paper which says that the Mohammed Suleimana has a valid defense in provocation?
I'll tell you why.
This position taken in the white paper is legally untenable. The only conclusion I can reach is that it was an attempt to shield government vigilantes. And so when Honorable Ndeburi said in his submissions that the key recommendation of the commission that the SWAT team at the National Security Council Secretariat be disbanded. And this has actually been dealt with in detail in the report. I think I referred you to page 45.
So round
of
up
the report,
quickly for me.
Which,
Let me come to
which
Prof.
talks
Example.
about the integration of vigilantes
Too much
with
lawyer
minimal
stock.
training, I mean, into the national security apparatus. So the only conclusion I can arrive at is that the white paper was an attempt to shield criminal elements who found their way into our national security apparatus and unleashed violence on innocent citizens on the day of the election.
Thank you. So just hold on there, and you say, I'm coming to Prof, but I want you to deal with that small question because you wanted to respond.
Yes, very much.
And you see, I've opened all these books.
Why is he alone having the right to respond to everything said on the program?
The government ought to have the right to respond as much as is possible. Just hold on.
I have a lot to say, but I haven't had the opportunity to express them.
Just hold on. Just hold on. Just hold on.
Just hold on. Why the Attorney General is stated in her white paper that there's a defense of.
Just hold on. So you agree that in this law, which is not the law like only in Ghana, but it's the standard of criminal law all over the world.
Correct.
So in the Criminal and Other Offences Act of Ghana, the provision is that the defense of provocation, which you have relied on to support this gentleman, is only available in a matter of murder. Now, you have our eminent judges all writing and referring to the same thing. Maybe because the commission included Henrietta Mensah Bonsu, I shouldn't quote Henrietta Mensah Bonsu, but this is her book.
Authority.
Yeah.
She's the authority. I have it here.
She's the foremost authority.
She's the authority.
So
by far.
she confirms that in this book.
She does.
The general part of criminal law, a Ghanaian case book.
Oh yes.
This is volume 2.
I have it here.
And then Justice Sir Dennis Ajay of the Court of Appeal, also writing in the Contemporary Criminal Law in Ghana, also notes that the provocation is a partial defense in murder cases. In murder cases. All of them confirm this. This gentleman, what is the basis of the provocation you are referring to? That he insulted some judge. Is that the case? If you read all the case law, including those referred to by Henrietta Mensah Bonsu here, determined by our courts in the Court of Appeal, insult cannot constitute the ground you are seeking to avail him.
First of all, I think it's not in doubt, and that is why the question about insult constituting grounds for legitimate provocation doesn't even come up, because it's not in doubt that provocation, an accused person can only be availed of the defense of provocation in the trial of murder. And even with that, it's a partial defense. It can only reduce murder to manslaughter. That is not in doubt, absolutely not in doubt. But in the same token, number one, white papers are...
So this is a grave error on law.
No, hold on. The white paper issued by government is a policy directive. The cases are bound. Kwapon versus Ghana Cocoa Marketing Board, Frimpong Atafua versus Ghana, and it goes on and on, a plethora of cases, that the white paper is a policy directive of the government, which has...
policy directive to change the law of Ghana, is that what you're saying? Not even the law of Ghana, but the law generally across the world?
And which has legal ramifications. Now, per Article 88 of our Constitution, and case law, Supreme Court case laws, a recent one being Afoko versus Attorney General, the Supreme Court has established, and the law is clear, that the Attorney General has a discretion, the unfettered discretion to prosecute. So when a docket is before the Attorney General, or recommendations before the Attorney General, or referral is before the Attorney General, it's the Attorney General who makes a determination to prosecute. There is still a raging debate and raging agitation, ongoing agitation in our country on the Attorney General and the investigative apparatus of our state to prosecute double salaries, for instance. The Attorney General may decide to prosecute.
It's a political decision.
Yeah, it's a decision taken, arrived at, taking into account the totality of circumstances. So that, hold on, the Attorney General has the right to determine, taking into account the totality of all the circumstances, even though some members of parliament are alleged.
So get to the point. The decision, the Attorney General's decision, the Attorney General's decision is that you can't prosecute because there is a defense of provocation.
Hold on. So I give you that example, that white collar crime. So people have taken one salary here, another salary here, clear cut stealing or whatever. The Attorney General is entitled to prosecute. And she may take other considerations and say, this is not a matter that I find justifiable, this is not a matter I find conscionable, this is not a matter I find to be in the public interest to prosecute, and therefore, I am not going to exercise the powers vested in me pursuant to Article 88 of our Constitution to prosecute.
That's not what she has said here.
In this white paper, the Attorney General and the defense of provocation as raised in this white paper is not in the strict sense of the defense of provocation as you have rightly enunciated, pursuant to Section 52 of the Criminal and Other Offences Act. It is the Attorney General taking into account the totality of the circumstances of the events of 31st January 2019, given that Sam George had been seen clearly as some aggressor, uttering words of insult to a security official.
So it says a policy decision.
Yeah, it's a policy
and the policy decision is that the policy decision is that there's a policy decision to override the law and to establish a new law or sort of policy. That's when you get insulted, you are justified to slap.
No. What else? No, hold on. No. That one substance. Listen to me, Kev. That one, the Attorney General has a discretion to determine whether to prosecute. Undoubted. Two, that there are cases where plea bargain and so many other circumstances where there is a clear case
Section 35 of the Courts Act is there, we know.
That there's a clear case of crime before the Attorney General. But when the Attorney General, even in the national interest, public interest, I can give you examples of...
That's not what the Attorney General has said here. What the Attorney General has said here is that the government does not accept the Commission's recommendation that Mohammed Suleimana must be prosecuted for the offense of assault, to wit, the slapping of the Honourable Member of Parliament, Mr. Samuel Nete George, on the basis that the Commission, at paragraphs 6.1 and 6.2 on page 55 of the report, accepted the facts which led to the assault, which is insult, on the Honourable Member of Parliament, Mr. Samuel Nete George, which facts support a valid defense of provocation for the said assault.
Not a valid legal defense.
What else can it be?
A valid defense of provocation. A valid defense, you may critique the language, you may critique the use of the word provocation, but I'm saying to you that the Attorney General's conclusion that there's a valid defense of provocation is not in the intendment of the four corners of the criminal laws of our country that is entitled to the legal defense of provocation.
But what else?
What else that if you take the totality of the circumstances, the gentleman was provoked.
But granted that this is to say that the gentleman is entitled to a defense in provocation, granted. Is it the Attorney General who must be saying that, or you prosecute the person and allow them to put their defense? The Attorney General will be prosecuting for the state, will not be a defense attorney.
Correct.
So what's the point?
So let me ask you a simple question. Let me ask you a question. Well, it's a contentious matter we can go on and on.
Why does the Attorney General not allow the government, not the Attorney General here, why does the government not allow the court to say Mohammed has a valid defense?
Yes, but do you agree with me that there are circumstances or situations where the Attorney General can take a criminal matter to court for the court to make a pronouncement, for the accused person to mount his or her defense, and yet the Attorney General can come to the conclusion this is not a matter that I will prosecute for giving reasons.
Thank you.
Do you agree
Professor Jampo.
The Attorney General has that discretion. Just as she's not prosecuting for double salary.
Ignore all the legal gymnastics. Sorry, it's okay. Gentlemen. Thank you. Please, let's respect our discerning viewers and listeners. Thank you. Gentlemen, James, and sorry. Yes, Prof.
Right, Samson, I think don't put me amongst two extreme partisan lawyers. I don't want to be among.
Proceed.
Yeah, they take all the time.
I'm looking at you with the flag on your your shoulders.
So they've said so many things and taken all the time.
Okay.
I want to speak my mind.
Please do.
Okay, and I'm speaking my mind purely out of political thoughts and political thinking. I don't care about what the law says. The laws were made by human beings, and they cannot usher us into a regime of robots. We must interrogate to see whether they make sense or whether they serve the interest of people. First of all, vigilantism has been a challenge in Ghana, particularly during the Fourth Republic. I mean, the first time we got caught in that quagmire was in 2001, when there was the first time that power was democratically changing hands from one regime to the other. People could not distinguish between the change of government and overthrow of government. That's in Yitu Abain and Yesasa Abain. And so people who felt their government had been elected took the laws into their own hands, and they did so many things that were very bad and threatened to relapse our democracy. Since then, we've had the issue of vigilantism plaguing several aspects of our electoral politics and all that. And I must say that I was very happy, and I indeed commended the president for being the first person to set up a commission of inquiry to probe or to look into the activities of vigilantism, in the history of Ghana's Fourth Republic. And then also, he's not done only that, but he's gone out of his way to also initiate a legislation against the phenomenon. Yeah. And I think it's something that is commendable. Don't say yet, yes, let me finish. But I hope that we as a people and the president and also the political elites around him are truly committed to the fight against vigilantism. Because in my view, having a commission of inquiry submitting its report and then also having a legislation that outlaws vigilantism would be meaningless if there is no political will and commitment to fighting it. There are so many legislations in our statute books that are not implemented, and so many things happen. And so, in my view, having a law against it would be meaningless unless the political elites are themselves committed to fighting vigilantism. Now, coming back to the report and then the work of the Commission of Inquiry, I think I've listened to what they've said. I have my own view, and I'm sure you are going to allow me to articulate my views too. In my view, it is not too polite for the government to describe their work as being partial. I find it difficult to come to terms with that description. And I agree with Dr. Osai that if they failed to do their work partially, then ab initio, the work should have been rejected. Okay, and with the greatest of respect to whoever authored the white paper, I have looked at the white paper, I've looked at the terms of reference, I've assessed their work. I don't think we can comfortably describe what they did as being partial. I don't think so. I think that they are also human beings. They are fallible human beings. They are prone to mistakes and all that. But the way we describe their work, we've described their work as they failing to faithfully and impartially, discharging the duty that was reposed in them. I don't think the caliber of people who constitute. No, please, when you are talking, please. The caliber of people who constituted the commission of inquiry are not mean personalities. Okay, in fact, these are not party foot soldiers. These are competent people who have no autopilot partisan interest. And so I am a bit worried. I don't know whether you've spoken to them, but I'm sure they are not speaking against this out of courtesy and respect to the president, but they are not taking the comments lightly.
Why is it that, why is it that we'll be doing what some may say is the faulty binary projection in thinking? That once I say something is not white, then it's black. I say the report is not faithful, it's not truthful, it's not impartial.
How unfaithful
have I by saying so said it is partial?
No.
It is untruthful.
Samson.
It is unfaithful?
How unfaithful and how untruthful is a report? We can disagree with some portions of the the work. But the point is to describe it right from the word go as unfaithful and untruthful.
They did not say so.
Well, it said the work, they failed to discharge their work in a faithful and an impartial manner.
Failed to do the report
failed.
Yes.
Yeah.
So it failed to do the most critical term of reference.
The report was authored by human beings. Okay. The report didn't originate on its own, and it was authored by human beings. So it is important that we make this point that if we will continue to set up commissions of inquiry, and then after their findings, we will behave as if we knew the facts before we set up the commission, then it is not important for us to have commissions of inquiry set up. And I agree with you, the government may have the mandate to scrutinize the report of any commission of inquiry. But we must, as a people, begin to rethink that mandate that government exercises anytime it sets up a commission of inquiry. Because in my view, if we don't take care, we may be promoting, we may be in the discharge of that mandate, we may also be funding impunity. There's been several instances where commissions of inquiry have been set up, and then government will issue white paper to counteract some of the findings and all that. I'm not saying that we should necessarily swallow everything into two, even if we disagree. But we should find a way, a fine balance or a fine way to ensure that we would not be going regularly on that tangent. Otherwise, then you may just be windows dressing a problem by just putting up a commission, knowing very well that while their findings, I would always have my way in counteracting it. And then let me go back to one specific issue that was a bit worrying. It has to do with the guy who slapped Sam George.
Yes.
I think that we must advise people on this. You see, no matter how right you are, you do not have to behave in a certain way towards a security officer or somebody who is holding a gun. Okay, you may be dead before the person will be found guilty. No. You may be dead before the person may be found guilty. You may not know the state of mind of that person at that time. Okay, that's notwithstanding, I think that
you're saying that if a security man is abusing my rights, I should shut up.
I'm not saying that. I'm saying be careful in the way you comport yourself, before a gun-wielding person.
But that's not how our forebears built this country.
Well, that is not how. They confronted them. Yeah, but I'm saying that you should be careful. I'm not saying you shouldn't react. I'm saying you should approach your attitude towards that person with a bit trepidation, so that you may be dead before the person may be found guilty. And it's important that I make this point. That's notwithstanding. I am saying that they can subdue you. I am saying that don't say anything for me. Keep quiet and let me finish.
Not for you.
And then I'm saying that it's the commission that did the worked like a court. And in my view, if they make a recommendation that somebody has to be prosecuted, it is up to the person. The government, in my view, goofed in exonerating that person. Okay, the person who slapped, Sam George. You should have allowed the flow of things. Let it go to court. Let the person go before the judges and say that I acted on provocation. If in the wisdom of the judges, they
cannot say that in the court because it's not a defense.
Well, but the point is that to exonerate him, and like you're saying, you can say that, well, because of XYZ, we are even filing. We are not interested in prosecuting the matter, in court. That can be done. But to exonerate the person in the white paper, in my view, creates an impression. You see that government is not so much interested and committed to the fight against, vigilantism, and I mean, it is worrying. So my point is, no.
We need to help. We need to help here. You see, if you are going to prosecute, it is government that will do the prosecution.
That's
government
right.
will go to court.
That's why I said this is more or less a political decision.
They should be sure that they will prosecute to secure maybe conviction or something of that sort. Now, if the evidence currently cannot support the prosecution, it will be extremely difficult for them to maybe go to court.
And so that's why you support the view that. So you support the view that.
What I'm saying is that it is a creature of our law. Because even if they are going to implement the recommendations, it is this same.
Okay, so don't take Prof's time. He's asking you the question which should end this discussion here.
So you are saying that government.
You support the position that there's a valid defense of provocation.
No, that's not what I'm saying. What I'm saying is that it lies within the right of government to do a thorough
a valid defense of provocation? in this case, is there a valid defense? Please, there cannot be legal or non-legal sense. It is a matter of legality. So it shouldn't be legal.
We know within the law it cannot be a valid defense.
Okay, so what are you saying then?
What I'm saying is that it lies within the right of government and Attorney General to do an analysis of the issues and check whether they will be able to prosecute it. That I agree.
That should not be done in a capricious manner.
So
we are importing capriciosity in this matter.
Sorry, James, hold it. Yes, please proceed. Proceed.
In my candid view, I think that particular part of the report that exonerated this guy was not politically, wise thing to do, because it creates an impression that you are supporting or you are finding impunity. He slapped him and all that. I mean, it's not something that we want to promote in our body politic, and I think it's something that government would have to take a second look at. Generally, in your own analysis, I read your report, government rejected about 59% of the report. And I'm just, so majority of the findings were rejected. And I've just been thinking about, if we would set up a commission of inquiry and then reject or accept only 41% of its report, then are we serious? Oh, really? If government knows all the facts, if government knows all the facts and knows all the issues, then in my view, it should go ahead to do whatever it wants to do. I mean, like, while the commission was even if the 41 are
please don't be interjecting. Don't be interjecting. Let me show to him. You see this Constitution Review report. This Constitution Review report. Do you remember what you said about it in opposition about government white paper?
But the white paper
Meanwhile, do you know how much of this was accepted by the government? Almost 90% of this was accepted.
Yeah.
And yet
you critique
you said
the government's white paper.
That should not be done.
Please. Well, I don't know what you're talking about, Samson, but in this we are just trying to deal with the issues fairly. I accompanied the then candidate Akufo-Addo in 2012 to appear before this commission of inquiry. And it was a closed door session. I know his views. I heard his views. In the same token, in the same light, check the president's public utterances on this constitutional review. In fact, 3 months ago, civil society organizations paid a courtesy call on the president, a working visit. So I don't know if you were there. And the issue, you were there. Oh, good. And the issue of the Constitutional Review Commission was put before him, and he expressed his views. Find out what his views are.
Okay, thank you.
You may be surprised about his views.
Yes, before this one, he has been talking about overhauling the Constitution anyway.
So the point is, the point I'm trying to make is that we must rethink the mandate of the president in giving opinion on white papers, and then white papers that virtually would reject almost everything contained in a report. Then it becomes an exercise in futility to put in place a commission to make fact find, anything. And I think we shouldn't be wasting money on said commissions if we know that at the end of the day we'll have our way by giving opinions that counteract findings. And I like the fact that you brought this as an example. Over 90% of the recommendations of the Constitutional Review Commission report was accepted. Only 10% and were rejected. But this one, you have 59%. If you do the approximations, 59% being rejected. And I'm saying that if we continue on that tangent, then at the end of the day, anybody who doesn't want to resolve any problem will quickly say, in the heat of the moment, I have instituted a commission of inquiry. But then we go behind the scenes to say that, well, at the end of the day, they can have their say. But I'm going to have my way by issuing a white paper to counteract whatever findings there are in, or recommendations there are in the report. And let us copy from best practices. You were citing, you were citing a lot of examples of white papers that have rejected, I know of all those white papers that have rejected work of recommendations of commissions of inquiry. You can talk about 1995. Rawlings calls some people were Yimo Osei-Wusu, Ibrahim Adams, and who were investigated, and some recommendations were made about them, adverse findings made about them. Rawlings issued a white paper to counteract. Okay, since then, there's been several commissions of inquiry and there's been several white papers. And I'm saying that if we will go on that tangent, then it will just create an impression, in the minds of people. Anytime you put in place a commission of inquiry, I mean, people will say, well, what would they do? They would have their say, but then the government will have its way. And it doesn't inure to the benefits of our country as we try to do things or seek ways and means of doing things right.
In the Constitution Review report at page 318, they made a couple of things. I want to read just one of the statements they said. They said Article 280, which allows a person aggrieved by the findings of a commission of inquiry to appeal to the Court of Appeal, does not expressly endorse or prohibit the initiation of criminal proceedings based on the findings. Then they said at paragraph 2111 that the Commission finds that public interest will be best served if the adverse findings of a commission of inquiry can be used as grounds to initiate prosecutions. However, this should be subject to the outcome of an appeal process initiated by the person aggrieved from the findings of a commission of inquiry.
This is what the government accepts. The government accepts the Constitution Review Commission's recommendation under paragraph 178 that the amendment of the Constitution to provide that prosecution may follow from the findings of commissions of inquiry set up under the Constitution.
So if we had done the amendment, we'll not be discussing this. Okay,
so
thank you.
Thank you.
That's the position now. It's the position now. Yeah, it's the position now. We take a break here. We'll be right back. And when we return, unfortunately, we have two other topics. We have to go to those other topics. Even though my panelists have been saying that today we should just discuss this matter and go away. I don't know what the production will say because my instructions are that we terminate this right here. Okay, I'm told an absolute no. When we return, we shall find some other platform to have a discussion going forward. I hear all of you saying no. We take a break here. We'll be right back. Platform, and here on Newsfile we put Ghana first, and my guests on the show have been Samuel Abu Jinapor, Deputy Chief of Staff, Professor Ransford Jampo of the University of Ghana, Dr. Eric Odrosai, Governance Expert, and James Agaga, former Minister, Deputy Minister of the Interior and a Member of Parliament. Now we have to get to two other issues that we have tabled, and I'm sure that we can deal with them very briefly. We apologize. I know most of you are reading the messages. You feel that we can continue with just this report, but the report is a lot. You can't use only this platform to exhaust it, so we can understand that we can do further discussion because it will come up. So thank you very much. You know the matters as regards the missing, tardy girls. And the police has come forward to sort of give us the conclusion. After they got samples, they took them to the laboratory, did a DNA test, and they have come to confirm that the girls are actually dead. Many have been unhappy in the manner that this has been done. I don't know. Deputy Chief of Staff, what do you think about how the police has handled this matter? They've been faulted, for example, for not going to these places earlier enough to get these remains until everything else was lost.
Well, thank you very much, Samson. But before I do that, if I may just quickly make a point about the matter that we're discussing, the Commission's report which we were interrogating before.
So I'm stopping you on your time.
Yeah, I hear you, no problem. Which is just to make the very categorical statement. That's the position of government. You find that in the white paper. The government is very happy. It commends the members of the Commission for their work. We don't doubt their stature, their astuteness is the reason why the President appointed them. And also to say that to just reduce reports of Commission of Inquiries and white papers to percentages is very simplistic. To say that this Commission of Inquiry accepted 90% and that Commission of Inquiry accepted 40%. One recommendation of a Commission of Inquiry may be more fundamental and far-reaching and substantial than perhaps all the 90 recommendations that are accepted.
Let's go to
and the most fundamental one is rejected. So the conclusion I want to make is that government is happy with how it has gone about this issue. It set up a commission of inquiry to delve into this matter. It was unprecedented. Thankfully for the people of Ghana, you are not happy with interjections.
Okay.
We are happily for the people of Ghana. It's been established that these people were not hoodlum, they were not invincible.
I'm prompting, if you don't get to the tardy girls, you may lose your
opportunity. They were legitimate. A legitimate organ of our national security apparatus. It was established in 2010. There were no deaths, and the government has come up with this position. I think our democracy is the better. The matter as to whether or not the constitution should be amended so that the president will not have the right to amend constitution. The governance experts and the political scientists can debate it, and the country can take a position thereof. But fundamentally, we think that...
What does the president and the presidency think about how the police have gone about the Tardy girls' search and conclusion?
First of all, it's always been a difficult matter. Samson, history teaches us, and that historical background is so across the world. We expect that our police service and our investigators resolve crimes as quickly as possible and as successfully as they can. But the truth is that in crimes of kidnappings and murders and killings and so on and so forth, it turns out to be a complicated situation and a difficult one for every police force. There are examples. I don't justify in any terms the incidents that took place in Takoradi, but there are examples in United Kingdom, in several other parts of our world where crimes have been unresolved to date, 5 years, 10 years, sometimes 40 years before they get resolved, even with the most sophisticated and enhanced capabilities. You will still find that certain crimes are difficult to resolve. Now, I want to also say that it is quite comforting that as we speak, there seems to be some closure to this Takoradi girls' crime. I've had issues of the authenticity or the credibility of the DNA inquiry and its findings and so on and so forth. But essentially, at the very least, the Ghana Police Service have been able to walk the country through what happened and the steps they took and the results that came out of the steps they took. And of course, there are those who have critiqued or criticized the police in their work and in how they have dealt with this matter. There are others too who have come to the conclusion or taken the view that the police, to the extent that they've been able to come to some conclusion in this matter and apprehended the perpetrators, should be a source of encouragement or a source of comfort for us. I think we have to continue to express our deepest condolences and sympathies for the families of these girls. All of us will have to learn some lessons out of this. The police itself, and I believe that the Ghana Police Service is not an exception. Every police force will do a postmortem and an introspection or interrogation in any major crime such as this.
The president has a decision to make. Let's go straight to it. The president has a decision to make as regards the fact that the head of investigations, CID, criminal investigations, had pronounced that the girls were alive and that they were safe. They will bring them to their parents alive.
Who makes that decision?
I said he has something to do about the circumstance. People say if this woman will not resign, she should be losing her job. In fact, she should not have been sitting in that meeting that announced that the girls are dead.
Okay. Samson, I hear you, but let's deal with it in two parts. The first is, and you say the president has a job to do. What job are you talking about?
The president recently promoted her to that job, not so?
Really?
Yes.
I think it's the IGP that does those promotions.
Okay.
It's the police council.
Is it
the police council that is headed by the presidency?
No, it's the vice president.
It's chaired by the presidency.
Is there any appointment that the president is not linked to directly or
Well,
indirectly?
in the constitution, is the police council.
That's why I said. That's why I made the point that we should disintegrate. We should unpack the issues. The question about
what does he think about that? Okay. What people are saying about him?
I'll get to that.
I can only give you just 2 minutes.
Okay. First of all, the police is quite autonomous. If you appreciate that, the police is largely autonomous, and the police force, all of us desire to be insulated from political interference and political pressures, and therefore. I will not find it appropriate to even discuss with the president as to what he necessarily think of a CID boss or whether or not the CID boss should resign or not. I think those matters are within the four corners of the Ghana Police Service. The Deputy Minister of Interior will attest to that. These are matters that are dealt with by the IGP. But what do I think specifically on the conduct of Madam Tiwa? Now, Samson, if you take a look at the IGP statement, I think to some extent, and I say this with all the sensitivities to the family and other people who feel outraged about the occurrences relating to these girls. To some extent, I think we are somehow a bit unfair to the CID boss. Because I've taken pains to read the statement and examine the chronology of events. I have no reason to doubt what the IGP has put out. In fact, I believe it wholeheartedly. And if you were to rely on the account of the IGP, at a point in time, the entirety of the intelligence suggested that these girls were in Nigeria.
Okay.
And so the statement
she should not be faulted. That's the bottom line.
No,
okay.
I haven't said so.
I need to move on.
I'm not taking a position on that, but I'm making the point that there is some level of, I think we have been a bit harsh on her.
Okay. All right, thank you. So, Prof, beginning from that point, some say this will happen only in Ghana.
Oh, really?
Elsewhere, she would have tendered her resignation long before.
Well, I don't want to limit my take on this issue just on Tiwa.
It's an aspect which is central to the discussion as to how the police have handled it.
I'll get there. You see, generally, I think the contradictory information and the seeming police complicity in the matter is something that is worrying and something that is making the family not being at ease with themselves. Someone allegedly aided a suspect arrested in this matter, to jump bail. And then we are told that the person has only been transferred. And then a key suspect in custody is insisting that the girls are not dead. The bones do not belong are not those of the girls. And then you have a police that comes out with an investigation, a DNA test to say that contrary to what the key suspect in custody is saying, the bones are the bones of the girls. I think it's creating a lot of issues here, and I'm happy that the family have requested an independent DNA, and it seems to me that the police is also acceding to that we'll give them the opportunity to go about things. But you see, the way and manner the police came out quickly with the DNA report, in my mind, creates an impression that someone wants to see a finality to this matter before 2020. It may not be the case. Please hear me well. It may not be the case. And I'm saying that if it is not the case, then the president himself must be disappointed in the way and manner the police has handled, some of the matter. And if that is the case, then he must be seen to be taking some action. First of all, the president himself must admit that he personally, he also didn't do well to personally, his failure to go there to personally commiserate and to console the family has not been helpful, because the matter at one point in time has still assumed a national dimension. And so I was expecting that as the first gentleman and the father of the nation, he would have gone there himself to personally console and to commiserate. Can I? No, I'm not saying that every kidnapping. Will you see, when I was doing that, you said I should stop. So can I continue, please? And so I was expecting
a bit
that.
of it is allowed.
Listen, a bit of it is allowed. Okay, go ahead. So I'm saying that, no, it's in his own interest. You wait, wait, please. Okay. So I'm saying that.
Is that a political issue?
Listen,
but don't overdo it, please.
No,
please don't overdo it. Don't overdo it. Can you make note of what he said?
What I'm saying is that
what
I'm saying that the president himself must admit that his failure to go to the family to commiserate directly with them and to console them has also not been
What would that
helpful.
have changed?
Yeah. Well, you see, the people are making issues. They are saying that the president went to a nearby town to say that we are still, investigating. Yeah. But he could have gone to them. You see, his best friend now, Jerry Rawlings, would have done that to win applause. Okay, so I'm saying, listen, please. He would have done. I mean, we are thinking about how to bring a finality to the matter. And so I'm saying that it may well be true that the people are dead and you can't find them. Okay, it may well be true. In that case, you don't give them that chance to continue saying what they are saying. That, well, we want this, we want that, and to continue to be criticizing the president. Okay. I'm saying that it is in the interest of the president. It's all is not lost. You can still go there. And he must admit that the fact that he picked up a phone and expressed the desire to talk to them on phone was also a disregard
and
of
we told one of them or all of them claiming that one of them claiming that they rejected
3 of them.
They rejected that
but I'm
call.
saying that
one has
you think that is okay for them to reject the president seeking to talk to them?
I'm saying
that's what I'm saying. You think that's okay?
Let me finish. I'm saying that was a violation of customary ethics and protocol on the part of the president. But at the same time, I was also expecting that the people, in spite of their grief, would have also accorded the president with some respect. Okay. And the point is, so it is all hopes are not lost. Okay. I'm expecting the president to make a personal trip to there, to console the family and to speak to them and to ensure or grant their wish for an independent inquiry and or DNA test again to be done.
The president has a representative in the region. If they do it, you don't think that's good
enough? It's assumed a national dimension. Okay, and so I'm expecting that he does that. But after that, I think he must also deal with people who have disappointed him in handling this matter, in whichever way he deems fit.
People such as?
Well, there are so many people involved. You are talking about security agencies, you are talking about ministries and all that. In whatever way he deems fit, I think he must deal with them as a way of telling the people.
If the police brief the minister and the minister repeats the briefing to the public, they should be punished?
Yeah, I'm saying that somebody has not done something well. Somebody came out openly to say, we know where they are. We are going to bring them alive.
Based on intelligence available to
well, but he should have said based on intelligence. So the person didn't communicate properly. Okay.
You can say that.
After that, there's been other people who are allegedly, involved in it, and they aided, one way or the other, some suspect to escape jam bail and all that. I think that something must be done.
Been rearrested, isn't it?
Okay. Interesting.
Something must be done to show.
Thank you about that, Prof.
Yes.
Yes. So, Doc, even the Daily Guide, which has, undoubted connection to the presidency, reported that they had been rescued. Here we are.
Samson, you see, condolences to the families, but my position is that, one, we should not run down our state institutions. Two, I think if we've gotten to a point in time in the life of a country where we should properly secure our borders and we should tighten our immigration laws and we should be sensitive to the activities of foreigners in this country. I am surprised the Nigerian police and Nigerian government has not issued a statement on this matter. I am surprised.
The IGP commended them for their support.
Yeah, the IGP commended them. But the Nigerian police, the Nigerian government, should have issued a statement on this matter, because your citizens have been complicit in this matter. You understand it? Then let's come to the issue of the police and their role, TY, etc. When you look at the statement read by the IGP, the one under arrest of first suspect, it seems to me that they had a very evidential basis for making a statement that the children were alive. there's this last but one paragraph that states that the evaluation, in fact, let me start from here. The evaluation, however, it said the evaluation of this confession, there was a confession that the children were alive, the kidnapped young girls were alive, and that they were sent by road to a location in Nigeria known as Baby Factory in Anambra State in Nigeria. Then they said this key suspect denied knowledge of the whereabouts of Ruth Abaka. And then this is the IGP speaking, that the evaluation of this confession and other intelligence reports from Nigeria on the location and modus operandi of this baby factory in Nigeria culminated in an assessment by the investigating team at this stage that they had a fair idea of the location of the girls and that it would be possible to bring them back home. Yeah. So my understanding is that, or my interpretation of this is that this informed or formed the basis of Madam Tiwa coming out to say that they knew where the girls were.
You are saying?
I am saying
that the police should take a confession statement without corroborating same and confirming and verifying same, come to tell the public that the girls have been found and should not take any responsibility at all for that. All they have to do is to just tell us anytime somebody tells them something.
Samson, the statement continued that several surveillance operations were mounted in Onitsha, Akwa, Port
when the people, whoever told them that the girls are alive, was it a duty on their part to confirm same before they transmit that information?
Yes, it was a duty on their part to do that.
So if you fail to do so, what is the price for that, or none at all?
Well, the statement indicated that they followed up. They said they followed up. It was at a point of following up, they realized that no, they've misled. That was after they had come out to inform us that, look, the children were alive. That notwithstanding, my view is that, you see, as a country, the police service will continue to be the police service. We need to give them all the
this
support.
entity was leading us in warfare, would have been killed before they have the opportunity to come back to say
but the
something
police
else.
Doesn't lead us in war.
No, it's just an example I'm giving. Shouldn't some people be paying a price for that?
Are we saying that with security services, no, I don't hold brief for any of them, but are we saying that security services don't act or get intelligence which turns out not to be credible?
Just the same way,
and therefore
just
they,
the same way,
not allowed to brief
just the
us
same way that the physician ought to be careful that they don't kill you or give you a wrong diagnosis. And the same way as a lawyer, that if you give negligent advice, you pay for it.
Absolutely, but I'm saying to you,
why is it that in their case they ought to be immune from any responsibility?
No, nobody said they should be immune.
He's raising very legitimate.
We are saying that they had intelligence, and to the effect that they had intelligence, it's okay. Everybody should move on.
No, that is not okay. They had intelligence. They acted on the basis of the intelligence. It turned out that it was not true. That is not true. So it wasn't credible.
Did they act on the intelligence professionally?
Well, I do not have the capacity to do a professional assessment of the steps they took. But my understanding is that what I think we should be doing is that we should prompt them to rather step up their game anytime they have this actionable intelligence information.
Is it believable to you, the remotest, the suggestion they make about the girls being transported to wherever you are talking about, and yet they are brought back to this country and their remains are found here? Is it?
No, it's not possible. That is not possible.
Or that they were not sent out at all.
That they were not sent at all. That they were misled. It's also a possibility. It's also a possibility. You know, that is why I am happy the police has admitted and accepted that, look, if you want an independent DNA investigation, that is also available. But you see, it tells us that as a country, we need to set up.
Okay, James. And this is the way to set up that nobody takes responsibility for anything. That's how we set up. Is that how you read this?
Yes, I'll come to that.
Please, James, it's a question to James. Sorry.
Quickly, before I
don't
answer your question, I just want to make the point.
Yes, James.
That government's white paper on the Emile Short Commission's report is a disservice. It's a disservice to security sector reform in this country, and we must all accept that. Look, the report clearly made the finding of fact that the existence of an operational unit within the National Security Council Secretariat is unconstitutional and unlawful and should be disbanded. Like I said before, most of the findings of fact the Commission of Inquiry made were based on law. Unfortunately, the white paper rejects this finding, which is based on law. It's very unfortunate. Which law? It's unfortunate.
Which law?
Article 202. And the Security and Intelligence Agencies Act 1996 does not allow the Secretariat to maintain an operational unit in the form of a SWAT. That is the point. So it is neither here nor there to say the unit was established in 2010. That doesn't cure the illegality involved in setting up such. So I'm saying that the Commission's report does a great disservice to security sector reform, and that must be taken note of.
James, Star D girls.
Star D girls. Government's handling of the kidnapping of the Tadi.
Government's handling.
Yes.
Not the police.
It's undesirable. The police is part of the executive. They are superintended.
When you are in government, you would have accepted this assertion.
Yes.
Okay.
They are superintended over by a ministry. Yeah. The ministry has its political headship, and so you cannot distance government from the lapses and the security failure that occasioned with respect to the
certainly you find yourself girls. In government sometime. I'll bring you back to
Samson.
Well, when you are in government, you want to separate the agencies from the word government. But when you are not, everything is government.
I want to make
in fact, everything is the president.
I want to demonstrate why this government's complicity in the matter.
Complicity.
I want to demonstrate.
Do that quickly.
Look, I filed an urgent question in Parliament. And that urgent question was directed at the Minister for the Interior. When he came to respond, because my question was, what measures government intends to put in place to forestall the future kidnapping of our girls in the Western region? His refrain was that, yes, in the past, kidnapping cases happened. But under their watch, he was able to tell us how they resolved the numerous kidnapping cases that occurred, including the kidnapping of the Canadian girls in Kumasi. Now, at the time he responded in this manner, the issue of the DNA results had not come about. And so we couldn't say whether or not the government had been able to resolve the kidnapping of the Takoradi girls. Today, the facts have come out that they were indeed murdered. When I further questioned the minister whether he had a role to play in the announcement Mami Tiwa, the Director General of the CID, made, his refrain was that the CID was on its own when it made that announcement. And so the point I am making is that any responsible government would definitely have held somebody accountable and responsible for the security lapse that happened, which then resulted in the unfortunate deaths of the girls, as can be established by the DNA findings. No, you see, please, when you were talking, I was very patient with you, so don't interject in this manner. So the point I'm making is that government failed us. Somebody ought to be held accountable. And so those who are calling for Mami Yatiwa should have done the honorable thing and not waited for anybody to remove her from her position. Okay. I made the point that the very least government could do is to reshuffle her from that position. If she wouldn't do the honorable thing by tendering in her resignation.
He actually said something that I think most of us also didn't pay attention to. The police council can promote up to ACP.
That is so.
That's the end of it. The rest of it, it is the president.
Yes. So my point, government's complicity.
So when I ask the question that the president can have a role in that, how does he feel about what people say has been the role of the various people, particularly the questions of ultimate responsibility?
Absolutely. So somebody appointed for instance, the commanders of our security agencies, because Mami Yatiwa said that the failure, she didn't deny the fact that there was a failure on their part. Rather, what she said was that the failure was collective in nature. So if that failure was collective in nature, the buck stops with the president, because he is the chairman of the National Security Council.
Can I respond?
Okay. So my point is that government's complicity in this matter.
It's the vice president that chairs the council. Yeah. The police council.
Absolutely, but the president
chairs
President Adu
chairs the National
Security Council.
Okay, you're right.
And so the buck stops with him.
I see.
So he must be held accountable for the murder of the Takoradi girls.
I need to take. Sorry. I need to take a break. Sorry. I need to take a break, and when we return, we would also briefly look at the question of the placement's quote-unquote mess and the political twist to that question. We'll have very limited time, and I'll share a few of your messages with you. Let me share this one here directly about this matter. Richard Asante Yeboah, who is Deputy National Communications Director of the NPP, says that I wish, said on the Tardy girls, unfortunate end, but I honestly wish the story was entirely different today. However, we are at a terrible end regarding the security agency's intelligence lead, apparent failure. This does happen sometimes, and history tells us that even the most sophisticated intelligence agencies and countries do get it wrong sometimes. I remember the USA invasion of Iraq on a phantom weapon of mass destruction. Let's be a bit charitable to the police and applaud the efforts they continue to put in securing our nation. Condolences to the family. We'll take a break here, return to ask the questions. Was the NDC busing people who have no business in going to school to be at the, at the center? We'll be right back. You're welcome back. This is Newsfile. It's your most authoritative news analysis platform. And a message from Professor Stephen Kweku Asare, popularly known as Kweku Azar. He says, a commission is a multi-purpose vehicle whose report includes opinions, findings of fact, recommendations, and sometimes adverse findings. He puts in bracket criminal or civil. Government is free to do anything with these opinions and recommendations, but cannot, and he puts cannot in caps, disturb the adverse findings, which are deemed to be a judgment of the High Court. Okay. A white paper cannot, once again, cannot is emphasized, disturb an adverse finding. Only a court of appeal can vacate such adverse findings. That is why certain adverse findings disqualify people from becoming an MP, or for that matter, from holding several other offices, including to become a president. So it is important to distinguish among other opinion, recommendations, and adverse findings. The only way for a government to get around adverse findings is to imprison, not publish the imprison. And he says imprison by saying imprison, he means not publish the report and explain why it has done so. Once the report is published, the adverse findings are beyond executive cleansing. Okay, so I think that's deep and thorough. Thank you very much. Jake says, I really wish that Eneskofi Abochi was part of the Newsfile panel today. I really wish. And he's asking, Samson, don't you feel sad, embarrassed, sitting down there and listening to your colleague lawyers speak like someone learning English as a second language on legal matters? Okay, my team, my production, as I understand, did everything, but the commission will not engage the public after it has finished its job and handed the report to where it must hand it. Right. So thank you for those messages. Now, the CSSPS, is it SSSPS? Yes, PS, and the matters arising. Did any one of you follow what was happening at the Independence Square? Yes. We are told in the 4,000s or plus people massed up there from Monday, and some had been there earlier last Friday or so and had problems. But the education minister has a twist to all of that story. Can we hear him briefly before we hear the comments? For those of you who have the benefit of the television, as you can see, that's crowds. And obviously very frustrated. And you saw videos, some of them, as you can see them sitting there, and the queues that you saw there. And some of them turned the place into a prayer ground. People leading prayer sessions. And you saw the prayer sessions happening at night. We're told some were there at dawn. And is that Gifty and Apia there? Or yes, people helping police people, all of them at the place. And we're told that some people actually collapsed. Some people got dehydrated and collapsed. Matthew Poku Prempeh says that some of those collapses were fake. Yes, let me start with Professor Ramsford Jambo. Yep.
Thank you.
Kwabrani, NHSK, didn't go for good bus,
Independence Square.
Independence Square.
Obi didn't go for good bus.
Bus, went to your
How?
So we may travel to my sister station, no broadcasting. But I don't say,
but that's a serious allegation.
I'm telling you, Kwabrani, NHSK, say.
Kwabrani Bain, no.
Oh, Sagana and she, the infant man, no Mary president. Ghana and she, and the president will pay it. Yin, non comedy.
Now, and
everybody will be but in the Canada and Kagana.
And only the Minister of Education, Ghana.
You did a big canon. So Obomohono, baby, you don't go back to so amazing.
No, but the point is, Omu Ababi Guhua, Obi Neba, Bema, Yamane girls school, Obi Oba, Yamane boys school, Obi say, Obi, of our board in Yamane day. Are those not genuine concerns?
Obi, computer did a castle will be a Bema and I will be Oba. I have 4 money per coffee layer, and then per croy mistake. So you say computer.
All right, so essentially all he said, and you just heard him, is that someone decided to pay people and bus them to the Independence Square so they can cause disaffection for the government. When he was probed who this person was, he said somebody who wants to be president and who actually does not care if the country bends so that they become president is the one responsible. Enimwa Enimado of Joy was there from the first day reporting from at dawn, and she reports that she never saw a bus busing people to the place, and all the people that they interacted with actually had their index numbers, genuinely were people who had issues with their placement. So, Professor Jampo.
Well, thank you. I think, as the minister said, and as my own investigations review, I have an adopted ward who also is going through the same process. About 75% of applicants had placement via the computer selection and placement process, and it's only 25% that, and you said we shouldn't be doing percentages, but that's what the minister was doing, only 25% that had issues and all that. The point is, if it is the case that 75% of applicants had placement at a go, then I think we should commend the Ministry of Education for doing that. But as we all know, there were problems, and anytime there are problems, I expect ministers to talk about the achievement and then also concede that, well, there are problems and these are the ways and means we intend to go about surmounting the problems. I didn't really like the explanations that he gave. As a minister, to just say that somebody bussed people to the Independence Square just so that they will go and misbehave without providing empirical evidence to support that is unacceptable. It's a mere foot soldier talk that, in my view, should not be the portion of a minister of that stature. He must be mindful of that. I mean, he could have just said that, well, it went well, but there were challenges. And truly, there were real challenges that I'm sure he didn't want to talk about it. For instance, I know that those people who were asked to go and do self-placement, every school has a quota or the number of people it can take. And so once you get to that quota, you must cap it or prevent people from selecting that school. but you didn't cap. So if Infantsipim can take 100 students, and then it had gotten to the 100 students, and you asked people to go and do self-placement without capping or preventing them from getting there, then it means they would all be placing themselves in that school that is already, full and all that. So then in that case, they would...
Yeah. And James, briefly, you two, how do you react to these comments? He claims that he had seen messages, some sent to some queen mothers, asking a mobilization to come to do what happened.
The minister should be probed on these very serious allegations made against the former president. He should be probed. Look, Samson, President Mahama.
He says somebody who wants to be president. It could be an independent presidential candidate. It could be PPP, CPP. Why are you...
If you listen to the interview he granted in its totality, he definitely was referring to President Mahama. That is the conclusion I can reach. But Samson, I want to remind the Minister for Education that it was not President Mahama who changed the software that the CSSPS has used since 2009, barely 3 months to the placements. It was not President Mahama. Secondly, it was not also President Mahama who dislodged. You see, there was a working group which acted like a board to the CSSPS, and that body was known as the Ghana National Education, the technical staff of the Ghana National Education. It was like a working committee.
He denies that this thing has been...
Oh, this was confirmed. This was confirmed by the Ghana National Education Coalition. And following the confirmation, the minister has not denied. So the facts stands tilted against him. It was not President Mahama who dislodged that group.
What do you say? He says that the CSSPS program is a third party that handles it, private third party. These people at the ministry don't interface with it really. So what's the point about
Samson, it's not true. We used to have the technical working committee which acted as a board. But the minister has since dissolved that group and assumed personal responsibility. So he can now distance himself from any failures, okay, of the CSSPS. He cannot absolve himself of any blames.
Okay.
So it was not President Mahama who took these decisions. What happened was self-inflicted, and the minister must be held responsible.
Okay. Yes, Samuel.
Samson, first of all, I believe that the Ministry of Education will engage in some introspection as to how this whole exercise unfolded. And as a ministry, I believe subsequent years will see some improvement in the services they deliver. What is very gratifying and comforting is the fact that as at 10 p.m. on Friday, September 20th, Samson, out of a total number of 473,728 students who are qualified to be placed into senior high schools, 351,022 of them, constituting 74.1%, had engaged in auto placement and had been placed in found schools. Self-placement had 87,321, constituting 18.4% of the number of people who are qualified to be placed. And indeed, as I said, as at 10 p.m. on Friday, 438,343 students had been placed successfully, constituting 92.5%. And indeed, a comparative analysis of this percentage and previous placements suggests that this is the best so far. The number of students who sat for the examination are about 512,000. We have vacancies in senior high schools up to 520,000.
We have dealt with all of these figures
There's a point I'm trying to
the deputy director here last week.
I hear you.
We're just dealing with this political twist to it.
The point I'm making really is that this September, by close of September, the Ghanaian educational system at the secondary level will have 1.2 million Ghanaian children in school. For me, the bigger picture is that the government has taken up, arguably, if you want, one of the most ambitious and revolutionary policies in the educational sector since our independence.
That's not in doubt. What we are talking about now is the minister's comment that it is you know, there's political motivation for what happened
that
at the place.
That should be probed. That should be investigated. It's not far-fetched.
Is it something that you give yourself room to believe?
It is possible.
Okay.
It is possible. He's a minister, an astute minister. A minister I have a lot of respect for.
Okay.
One of the most outstanding ministers of our government. I have absolutely no reason to disbelieve.
It should be probed by who?
I'm saying that for the minister to make these claims, we should interrogate and investigate it because it is highly possible. The minister
so given that the minister has not responded to any police or anything, who should be probing it?
The security services should take a look at this because
so
the minister,
it
is possible.
Yes.
It is possible.
Should this be probed?
Definitely, I associate myself with that.
Who should make a complaint?
Well, I mean,
it's out there. It's an issue.
Well, you see,
it's one the system was hacked.
Well, whether the system was hacked or not, I think
all those happened and they resolved it.
Yes, I would expect national security to, institute a probe into this matter.
Okay.
Yes, and then I would also say that we should.
So they will call the minister.
They should invite the minister on the basis of his statement, and then we should have more grade A schools in this country because. You see, if we are not able to work towards having more grade A schools, we're going to have problems. Because free SHS means that we're going to have more students coming out of BEC. Okay. And then also, please, let us also work towards depoliticizing education. Education, health, and agri, you don't politicize it. Okay. Let us depoliticize it.
All right. Thank you very much. Thank you. 30 seconds.
Yeah, 30 seconds. What I'm saying is that if the president truly is committed to his vision of promoting free SHS, and I'm pleading with him, he should go back to the education ministry and to look at the relationship that exists between the key officials there. There is tension there, and it is such that some people would look on when there is problem for the problem to blow off.
Okay. All right. Thank you very much. Thank you very much. And I've seen some of your messages now coming in. We're sorry we are unable to read some of them. And somebody is pointing to the effect that you also disagreed with the use of militia because you say they did not define it. I'm told that if you check a particular paragraph, there was a definition. If you are expecting them to have said the dictionary defines militia as this.
No, but we defined
they have said, you did a definition.
Yeah, we did.
But they have said that these groups constitute groups that challenge official authority. So that should be militia. You say they were not, it was not defined, but they actually had defined it. Okay, thank you. Thank you very much. This is where we draw the curtains on today's edition of Newsfile. My guests have been Samuel Abu-Jinapor, Deputy Chief of Staff, Professor Ransford Jampo, Associate Professor, Political Science, and Director of the Center of European Studies, University of Ghana. Dr. Eric Odrosai is governance expert and lawyer. James Agalga is a lawyer and MP and ranking member, Defense and Interior Committee of Parliament. I'm Samson Ladi Anyanini. And my outfit, as always, is by Latida. Have a good afternoon. The news is up next.